Jason was heading home after a long shift, thinking about dinner, not legal trouble. A police car pulled in behind him. Lights flashed. The stop felt routine. Then came a question that sounded harmless, almost friendly. Jason answered without thinking. 10 minutes later, he was standing on the roadside, confused about how a simple conversation spiraled into searches, accusations, and delays. That moment is more common than people realize. Most police traps don't start with force or shouting. They start with words. In this video, you'll learn how everyday questions quietly shift control during a stop, and how one sentence can change everything. You don't have anything to hide, right? This question sounds reassuring on the surface. The tone feels relaxed. Many drivers hear it as an attempt to move things along. In reality, it performs a very specific legal function. It shifts the psychological burden from the officer to the driver. The moment that shift happens, people begin explaining themselves, volunteering information, and trying to prove innocence that never needed proof. From a legal perspective, this question has zero evidentiary value by itself. A driver has no duty to demonstrate transparency during a traffic stop. The law places the burden on the state, not the individual. Yet this phrasing quietly flips that structure. Once a driver responds with explanations, denials, or reassurances, those words become part of the interaction and can be evaluated, compared, and interpreted. The real objective appears in the follow-up. After a driver signals cooperation, the conversation often moves toward consent. If there's nothing to hide, you won't mind if I take a look. At that point, many people feel boxed in. Refusing suddenly feels confrontational, even though refusal remains a lawful choice. Consent obtained in this way is still valid under constitutional law, which courts have repeatedly affirmed. The U.S. Supreme Court has made clear that consent searches are permissible when given voluntarily. In Schneckloth v. Bustamante, the court explained that officers are not required to inform individuals of their right to refuse consent, stating that knowledge of the right to refuse consent is one factor to be taken into account, rather than a requirement. This is precisely why this question works. The absence of pressure does not require the presence of clarity. Once consent is granted, the scope of the search expands rapidly. Containers, compartments, and personal items fall within reach. Even when nothing unlawful exists, misunderstandings, misinterpretations, or unrelated issues can emerge. At that stage, reversing course becomes nearly impossible. A controlled response avoids this outcome. A calm statement declining consent preserves boundaries without escalating the interaction. No explanation is required. No narrative helps. Silence and clarity often protect more effectively than reassurance. This question feels small, but it changes the legal posture of the stop. And it sets the stage for another line that sounds even more casual, yet carries consequences most drivers never anticipate until it's too late. Where are you coming from? This question sounds conversational, even polite. Many drivers answer it automatically, assuming it helps show cooperation. From a legal standpoint, it serves a different purpose. It invites narrative. And narrative creates variables that officers can assess, compare, and interpret in real time. During a traffic stop, an officer may ask questions beyond identification. That does not mean a driver has a duty to answer them. The stop itself remains limited in scope. Courts have consistently recognized that roadside questioning can feel informal while still carrying legal consequences. In Berkmeier v. McCarty, the Supreme Court explained that traffic stops are inherently coercive due to the authority and control exercised by police, even though they appear brief and public. The court noted that a traffic stop significantly curtails the freedom of action of the driver. That context matters when evaluating how statements are later viewed. When a driver explains where they came from, they often add details without realizing it. Time frames, activities, companions, reasons. Each detail becomes something that can be weighed against observations such as fatigue, demeanor, odors, or inconsistencies. None of this requires wrongdoing. Human memory varies. Stress affects speech. Minor uncertainty can appear suspicious when filtered through authority. The question also functions as a branching point. A neutral answer may lead nowhere. A specific answer can open entirely new avenues. Mention a bar, and alcohol enters the discussion. Mention a long drive, and fatigue becomes relevant. Mention a friend's house late at night, and curiosity follows. The original reason for the stop fades into the background as the conversation expands. Legally, personal travel history falls outside the core requirements of a traffic stop. A driver must comply with lawful orders and provide required documents when asked. Explaining movements remains optional. Silence or refusal to discuss one's day does not create ground for detention or escalation by itself. Experienced officers know this question encourages voluntary disclosure. Many people talk to reduce tension. Ironically, that instinct often prolongs the stop. A concise response that declines discussion keeps the interaction narrow and focused. It signals cooperation with lawful procedures while maintaining personal boundaries. This question appears early for a reason. It sets tone, direction, and momentum. And once momentum shifts, another request often follows, framed as routine, carrying far more weight than it first appears. Mind if I take a quick look inside? This question often arrives wrapped in courtesy. The phrasing feels informal, even cooperative, which is exactly why it works. From a legal perspective, this moment marks one of the most important decision points in any traffic stop. What sounds like a request for convenience carries the full weight of constitutional consequence. Search authority during a traffic stop comes from limited sources: a warrant, probable cause, or consent. When none of those exist, consent becomes the fastest path forward. That is why this question appears so frequently. It seeks permission to do what could not otherwise be done at that moment. Courts have repeatedly held that consent searches are valid when given voluntarily, even without an explanation of a right to refuse. In Florida versus Ameno, the Supreme Court ruled that a suspect's consent to search a vehicle allowed officers to examine containers within the car that might reasonably hold the object of a search, stating that the scope of a search is generally defined by its expressed object. That principle matters because many drivers believe they are agreeing to something narrow. The law often interprets that agreement far more broadly. Once consent is granted, the driver loses control over where the search goes. Glove compartments, center consoles, bags, and other areas may come into play. Even personal items can become part of the process if they fall within the perceived scope. The officer no longer needs to justify the search. The permission itself becomes the justification. Another critical factor involves how consent is given. Words matter, but so does behavior. Courts have recognized that gestures, silence, or stepping aside can be interpreted as consent depending on context. That gray area frequently works against the driver. What felt like compliance in the moment can later be described as authorization. Declining consent requires no argument and no explanation. The law does not require cooperation beyond lawful commands. A clear refusal keeps the interaction within its original limits. It preserves rights without escalating tone or tension. Officers remain free to proceed if independent legal grounds develop. This question often feels like the final hurdle before the stop ends. In reality, it could be the gateway to an entirely different encounter. And it often sets the stage for a question that shifts attention away from the vehicle and directly onto the driver. How much have you had to drink tonight? This question carries more weight than most drivers realize. It signals a potential shift from a routine traffic stop into an impairment investigation. The wording sounds direct, even casual, but its legal impact begins the moment a driver answers. From a legal perspective, this question functions as a gateway. Any admission, even a single drink hours earlier, gives an officer a basis to extend the stop. That extension can include additional questioning, observations, and requests for tests. The driver may feel compelled to minimize or explain, believing honesty will resolve the situation. In practice, explanation often deepens scrutiny rather than easing it. A response denying alcohol consumption carries its own risks. If the officer later claims to observe signs associated with impairment, such as delayed responses or unsteady movement, the statement can be framed as inconsistent. Consistency matters during investigations, and perceived inconsistency can justify further steps. The question places drivers in a narrow corridor where every answer creates exposure. Legally, roadside questioning about alcohol consumption falls outside the mandatory requirements of a traffic stop. A driver must comply with lawful orders and provide required documentation when requested. Voluntary statements, however, become part of the record. Once spoken, they can be referenced, interpreted, and used to support investigative decisions. Silence, by contrast, offers no material to evaluate. This question also relies on social pressure. Many people believe refusing to answer appears uncooperative. That belief has no grounding in law. Cooperation refers to compliance with lawful commands, not the sharing of self-incriminating information. Choosing not to answer preserves clarity. It avoids speculation and prevents the stop from escalating based on words rather than observations. Officers are trained to assess impairment through a combination of factors. Verbal admissions accelerate that process. Without them, the officer must rely on objective indicators. That distinction matters. It keeps the encounter anchored to observable facts rather than assumptions created through conversation. Drivers often view this question as harmless curiosity. In reality, it marks a procedural pivot point. How it is handled can determine whether the stop remains brief or transforms into something far more complex. And it often appears moments before another question designed to test whether a driver will speak before hearing the actual reason for the stop. Do you know why I pulled you over? This question appears in almost every traffic stop for a reason. It places the burden of explanation on the driver before the officer has stated any allegation. From a legal standpoint, that shift matters. The moment a driver begins guessing, the interaction changes from fact-finding to self-directed disclosure. Many drivers respond instinctively. They search their memory and offer possibilities. Speed, lane position, a light they forgot to check. Each guess hands the officer information that did not previously exist in the encounter. What began as uncertainty becomes a statement attributed to the driver. In later reports or testimony, those words carry weight because they came voluntarily. The structure of this question invites error. Drivers often believe acknowledging a minor issue will appear cooperative. In reality, admissions remove ambiguity. Once a driver mentions a possible violation, the officer can explore it further, even if that issue was not the original reason for the stop. The conversation expands, and the scope of the stop can expand with it. Legally, the responsibility to articulate the reason for a stop belongs to the officer. That explanation provides the framework for what follows. When a driver guesses, they bypass that safeguard. They may unintentionally admit awareness of conduct or conditions that suggest negligence or intent. None of that benefits the driver. This question also functions as a consistency test. Officers compare the driver's answer with observations and later statements. Minor differences can be framed as uncertainty or evasiveness. Stress affects memory, yet roadside conditions rarely account for that reality. Once words are spoken, they exist independent of context. A controlled response keeps the process aligned with legal procedure. Asking the officer to state the reason for the stop maintains clarity. It avoids speculation. It prevents accidental admissions. It keeps the encounter anchored to the officer's stated justification rather than a list of hypothetical mistakes. Drivers sometimes worry that redirecting the question will appear confrontational. In practice, it does the opposite. It brings structure back into the interaction. The officer explains the reason. The driver addresses that reason. The exchange remains focused and measurable. Traffic stops often turn on small moments. This question represents one of the most consequential. It feels polite, yet it tests whether a driver will speak before understanding the allegation. How that moment is handled often determines whether the stop stays narrow or becomes layered with unnecessary complications. And once that reason is stated, another phase of the interaction begins, one where the tone feels settled, yet the final outcome remains very much undecided. Traffic stops move quickly, and most problems begin with words spoken out of habit rather than necessity. The questions you heard today sound harmless because they're designed to sound that way. Each one invites you to talk, explain, or guess when the law never required it. Knowing how to respond keeps the encounter focused, calm, and controlled. This knowledge gives you clarity, not conflict, and confidence without attitude. If this breakdown helped you see traffic stops differently, share it with someone who drives regularly. These situations happen every day, and preparation matters. Subscribe for more clear, practical legal insights, and stay informed so a routine stop stays routine.